Why won't my prior representative let me know why they dropped my case? Okay. Gotta stretch out and just gotta work the kinks out. Because I gotta get you ready for this one because I know somebody's gonna be pissed off when they hear what I gotta say. All right. First and foremost, if a representative lets you go, there's nothing, unless there's a particular state bar rule or state representative rule, whatever the case may be, there's nothing that mandates they have to tell you why they let you go. They could let you go because your breath stank. And you, man, that's jacked up. It could be the wind. It could be, and they could have been a variety of things. It could be they're scaling their practice down, they're phasing out that particular area. Maybe you have the type of claim that they typically would represent in the past, but they don't represent very much anymore. So they're becoming critical when it comes to certain cases. Maybe you're under the age of 50 and they're trying to keep all their clients over the age of 50. Maybe your case is an SSI case and they're not taking SSI cases anymore. Maybe your case is a kids case and they don't want to handle kids cases anymore. Whatever, whatever it is, they're within their rights to let you go. Remember, Social Security, and this is one of the things I have to explain to people. There are two types of law practices out there: contingency fee and billable hour. In billable hour practice, you pay the person up front. So there's no risk involved for the representative. They set up a dollar amount, you pay. If you don't pay, they just stop representing you. Just that simple. They get paid for the work they've done along the way. Contingency fees are a lot different. In a contingency fee agreement, the representative is rolling the dice that they're able to get a favorable outcome for you and hopefully get paid on it. Those cases can be, and I'm talking about, it could be yours or anybody else's, can be uniquely difficult. And what do I mean by uniquely difficult? Well, the reality is that with a billable hour case, you're going to pay me for the money of the work up front, regardless of whether I win or you lose your case. Billable hour cases are not contingent upon winning. That's the key of a contingency fee case. So what do you mean by that? Let's say you go and you hire me to review your contract, okay? And I tell you for a contract review, I charge $300 an hour. Guess what? I charge you $300 an hour. I tell you what it says. You may not like my review, but I did the work that you asked me to do. Pay up $300 for that hour. Family law case. You want a family lawyer attorney. I've never met a family lawyer that does a case contingency. They almost rarely do it. They almost do all of those billable hours. So guess what? They tell you in order for me to represent you in your family law case up to a trial is $6,000. And you're like, up to a trial? What do you mean by up to the trial? Because the reality is that this is how you have to understand. In a billable hour case, there's no back pay money to get paid off of. There's no lump sum settlement or award notice. The person who's going to make sure they get paid is the attorney from the client. So if the client is not in a position to pay, they're not going to do the work. So what happens is that they bill you for all, they say, okay, $5,000 and you pay them $5,000. And then what they do is they send you invoices telling you how they've drawn down off of that money based on the work that they've done. Billable hours, get paid up front. Contingency is contingent upon winning. That means an attorney, think about this. An attorney, like, for instance, I'm considered a consumer attorney. The National Consumer Law Center did an attorney surveys a few years ago. An attorney with my number of years of experience would command $313 an hour. So that means if I'm working on a contingency fee basis, in theory, my hourly rate, my non-contingency fee hourly rate is $300-something an hour. So imagine working on a case for 10 to 15 to 20 hours. And first of all, you get $6,000, which is the max if you get the Social Security hearing, and you get the max fee at the hearing, whatever the case may be. But imagine if the person loses and decides they want to go someplace else or gives up on their claim altogether. That means that's 20 hours worth of work that I won't see getting paid on. And because it was contingent on me rolling the dice that I could get you a good outcome. So most states recognize that contingency fee cases have a greater risk inherent in them. So guess what? When you're contacting a representative and your representative drops you, they've already taken a risk to take your case on to begin with. They don't owe you any explanation. So when people come to me, I'm always like, your rep they don't owe you an explanation as to why they let you go. They can let you go because you got some corns on your feet. I don't know, you breast stank. You got a funky hairdo. It's totally up to them. Now, what I would tell you is this: don't take it personally, and don't go out in a blaze of glory. What do you mean by take it personally? I say the fact that they let you go may have probably been a business decision. It had nothing to do with your case. I've had cases where I've taken cases on from other representatives where early on I was able to ascertain that probably there was a personality click. I deal well with certain personalities, probably more so better than others. And I'm pretty sure there's other people who deal with certain personalities I don't get along with. So that they don't owe you, don't take it personally. Okay? It's a business move. For your purposes, here's what I would recommend. If you have any kind of relationship with the individual, just ask them. I know that, be polite. And this is one of the things I tell people, because people never get it. That old school saying, you catch more flies with honey than you do vinegar, is dead on point. Because what happens when people get their cases dropped by an attorney? Fire and brimstone. They ready to set it off. I mean, they're ready to, you boy, let me take my shirt off. I'm like, you want to go start wilding out. I'm like, no, all that's not necessary. Just go up to the representative and say, listen, I'm looking for another representative, and I'd like to be able to inform that representative as to the reasons behind your choices of not letting me go. Would you be so kind as to tell me? Again, I'm going to go back to my original statement. The representative is not bound to tell you anything. Just because they let you go, don't take it personal. And if they don't tell you why they let you go, don't take it personal. Just keep it moving. Just know that when you go to your next representative, and I'm actually going to write a blog about tips for finding another representative. Keep a couple of things in mind. It's nothing personal, it's business. You're trying to win your case, so keep it moving, keep it moving.